I'm glad you could join me here at Clackamas Community College. I'm standing in front of our Faces of the Fountain. The college chose 18 influential people, and I'm standing in front of Chief Joseph of the Nez Perce Band out of Oregon. Today, here at the college, some of the students are going to do a mock appeal to the Supreme Court of the United States based on a case involving Chief Joseph and his band of Nez Perce and the Wallowa Valley out in eastern Oregon. The case is based on an appeal of a 1941 case before the U.S. Court of Claims. The descendants of Chief Joseph and his band of the Nez Perce took their case of an invalid 1863 treaty to the Court of Claims, arguing that it was an invalid agreement. The court held for the government in the case, deciding that it was a valid agreement and that Chief Joseph and his band did not have a claim of title to the Wallowa Valley. And so that's what this appeal is based on. They had a very good argument for lack of agreement, but we've had additional considerations since that 1941 case that make this a very appealable case. So in a few minutes, we're going to go inside and begin the mock appeal. It is really called a moot court competition. Harvard Law School is famous for their moot court competitions before the U.S. Supreme Court. So we're kind of doing a similar thing and hope to show that Harvard has nothing on Clackamas Community College. All rise. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Petitioner, are you ready?
Good morning, everybody. Thank you for joining us here today. We are arguing on behalf of Chief Joseph in terms of the Wallowa Valley. We would like to go ahead and note that this contract between the United States government and the Nez Perce as a whole was an invalid contract due to the privity of the title of land owned by Chief Joseph. We hold that the court erred when it held that the one entity approach to consummation of the 1863 treaty rendered it a valid contract by denying Chief Joseph's band their basic contractual rights. The one entity approach ignored the contractual rights afforded Chief Joseph and the autonomous rights recognized in the 1855 treaty. The contractual rights. Privity was established when an offer was made specifically to Chief Joseph regarding the Wallowa Valley, thereby recognizing this band's claim of title outside and independent of Lawyer and the rest of the Nez Perce tribe. In Davis v. Wells, decided by this very court in 1881, making it especially relevant, states, the agreement to accept is a transaction between the guarantee and the guarantor, and completes that mutual assent necessary to a valid contract between them. It establishes a privity between them and creates an obligation. Privity was established with Chief Joseph directly, and Lawyer was not involved in any of the negotiations or discussions between the government and Chief Joseph regarding the status of the Wallowa Valley. Your Honors, this is perhaps the most important element. The Nez Perce members that Lawyer gathered for the 1863 treaty lacked privity regarding the Wallowa Valley. Only Chief Joseph could accept the offer presented to them. Section 52 of the Restament Second of Contract states, who may accept an offer? An offer can only be accepted by a person whom it invites to furnish the consideration. There is no stronger evidence that Chief Joseph was the only person the government originally believed could accept the offer regarding the Wallowa Valley than the fact that they weren't evicted from the valley for 14 years, during which time the government continued to negotiate directly with Chief Joseph. This privity is further proven by the 1873 executive order returning the valley back to Chief Joseph's band as a mini reservation. Autonomous rights of ownership was recognized by the government, further proving privity of contract. The government, as stated, the Nez Perce members that lawyer gathered for the 1863 treaty lacked privity regarding the Wallala Valley. The government only changed the one entity argument for the 1941 court case, which completely sidesteps the privity established between Chief Joseph and the government that created an obligation as set out in the Davis case decided by this very court. Additionally, the Fifth Amendment takings clause would not apply here. This case is distinguished from the Sioux Nation versus the United States case, where this court held that any argument against the treaty involving the Black Hills was moot because the government could have taken the land by using the Fifth Amendment's taking clause. With this appeal, we argue that different than what happened with the Sioux Nation, there is proof that the government did not pursue a Fifth Amendment takings clause in a timely fashion intentionally. When Chief Joseph rejected the offer with the 1863 treaty, there was plenty of time to exercise the Fifth Amendment's takings, but Congress chose not to pursue this remedial effort when it was ripe. Chief Joseph's band was not evicted for 14 years, during which time an executive order even granted the valley back to Chief Joseph, proving that Congress never intended to use the Fifth Amendment takings clause. When Chief Joseph rejected the offer, it stands to reason that was the time to assert the Fifth Amendment's taking clause. And the decision by the government not to assert it at the time proves it was a deliberate move. In closing, Your Honors, we respectfully request the 1863 treaty with respect to Chief Joseph's band and the Wallowa Valley be held in an invalid agreement, and that all lands known as the Wallowa Valley at the time of the 1863 treaty be restored to the descendants of Chief Joseph's band.
If you say Chief Joseph had title to the valley, then why is that not reflected in the legal description of the 1855 treaty?
It becomes a more complicated matter when you go ahead and take the treaty into consideration. You have to bear in mind that the treaty, while being signed by Chief Joseph in 1855 and then not signed in 1863, makes for a very interesting situation when it comes to the autographs on the paper. However, the real issue about privity is the fact that by the government prior to the 1855 treaty even being signed, sought out Chief Joseph to go ahead and negotiate on behalf of the lands. They are creating the privity that he is the only party that can furnish the consideration for which they seek. Meaning that regardless of whether or not it is specifically laid out in the documentation of the treaty itself, they have established that Chief Joseph is the rightful property owner. As a result, they can go ahead and say that they had somebody else sign on his behalf, but at the end of the day, he is the only one that has any claim due to the privity they established before either of the documents were signed.
With respect to privity of contract that you say created an obligation to Chief Joseph with the 1863 treaty, didn't he cancel the obligation by walking away from the negotiations?
Well, as we previously discussed, there is the small matter of what it actually means to leave the negotiations. Now, you could make the argument that him leaving is him surrendering. However, I think that is a misguided direction to work in. In fact, I think that, as Hunter said, actions speak louder than words. When somebody offers you something so insulting that you can't even stomach to be in the same room as them, doesn't it say an awful lot more to merely walk out as a rejection of their offer as opposed to simply saying no? I do not think that he walked out to surrender his lands. I think he wanted to make it very clear how he felt about the offers that were being made by the U.S. government.
Why was it not established on record that each representative of the individual bands of the Nez Perce had individual title to their share of land in the 1855 treaty?
I believe that question goes straight back to privity. Within the 1855 treaty, it established the autonomous rights of the Nez Perce as a whole in the valley. Outside, we are talking about the Wallowa Valley. We're not talking about the entire valley as a whole. Because we are talking about the Wallowa Valley and the Wallowa Valley alone, we are recognized only to Chief Joseph, who is the sole title holder of this land. Any other signatures towards the 1855 or even 1863 agreement are irrelevant to this case as they do not pertain solely to the Wallowa Valley.
What makes this case any different than what we held in the Sioux Nation case, where we held that the tribe signing as one entity was acceptable and there was no breach of contract by the government?
Unfortunately, this case is not like the Sioux Nation case. The Sioux Nation case was a one entity arguing in bad faith, as we stated earlier. This is an argument of privity towards who had title to the land. As we've stated many times before, a lawyer does not have privity to the Wallowa Valley. He may have been the face of the one entity, but the one entity does not apply in this case scenario, as it is solely Chief Joseph who we are saying has privity.
Why should this court not hold that the agreement is moot? Because the government could have used the takings clause under the Fifth Amendment, like we decided in the Sioux Nation case.
This case is unique in that while the Sioux Nation was governed by one body, the Nez Perce operated as autonomous bands within the region. Not only that, the length of time that Chief Joseph led his band even further than reinforces our point that he was culturally the owner of the Wallowa Valley.
Are the respondents ready?
Yes, Your Honor. May it please the court on a less lengthy note that we, the respondents, disagree with the petitioner and respond with 3 key points. First, in the 1963 treaty, the court held that one entity approach to the Nez Perce created a valid contract. Second, in both treaties, Chief Joseph was never allotted a divided interest in the reservation or given an individual title, so that the court was correct in the assumption of an undivided interest when it came to the 1963 treaty. Thirdly, and most importantly, Chief Joseph's contractual rights were not at issue because at the time he had no independent rights due to the 1855 treaty and the fact that Indians at the time were not considered citizens of the United States, leaving them no independent rights until 1924.
I have 2 questions. So why was the government hounding Chief Joseph for 14 years after the 1863 treaty if they didn't believe he had title to the valley?
Again, Chief Joseph was upset that he was the minority in a majority vote, therefore he was upset.
Yes, but why? Why was he so special? Why did they spend 14 years going after specifically the Wallowa Valley?
Well,
and why did they chase him down 1,100 miles to Canada just for his title?
he had no title, although because he was making the most racket out of, again, the minority of 2 bands who didn't sign, they seeked to appease him in hopes to come to peace with him, where the government was not trying to create conflict until he decided to go about his ways and do what he will. In that case, we did see conflict.
Did he really, though? Did he really make such a big fuss out of all the other bands that were there?
Why would we focus solely on him if he did not?
Because why just him? There were 27 other bands that walked out with him that made just as big a fuss, so why specifically him?
Again, I asked where the 27 came from, and I remind you that 51 out of the 53 bands signed.
I have 3 questions. The first being, as you stated, Native Americans were not considered American citizens until the 1900s. How would American laws apply to them? Wouldn't the Fifth Amendment takings not apply to this circumstance if they were not citizens of the United States?
The Native American Citizen Act was enacted June 2nd of 1924. Therefore, you're correct. The Native Americans did not have any Fifth Amendment rights. However, as I mentioned previously, the government was kind enough to extend a Fifth Amendment right, in a sense, through these treaties.
Shouldn't the treaties have been treated as a barter between 2 separate nations as rather than part of like a Fifth Amendment taking under the government?
Yes, so a treaty is for 2 separate nations.
Mm-hmm.
So, but because these nations were so close together, we decided to, rather than create conflict, try to create peace, which is why the treaties were created in the first place.
I have 2 questions. The first one is, what makes lawyer qualified to solely represent and negotiate on behalf of Nez Perce in the 1863 treaty?
The fact that he signed the 1855 treaty, Your Honor, is the reason why. If he had not signed the 1855 treaty, then we could understand that maybe he didn't want lawyer on his behalf, but because he signed it with knowing that lawyer was represented as the head chief on the document itself, that it gave him the right.
Was lawyer the government's choice as head, or was he elected by the tribe members?
Your Honor, I don't know if there was an official election by the tribe, but by signing the 1855 treaty again, they did not protest or walk out of that contract, which would indicate that they were knowingly signing away that their rights to lawyer and letting him represent them.
Does Chief Joseph have a final rebuttal?
Yes, Your Honor, we most certainly do.
Yes.
Now, we've heard an awful lot today about why it is that these not citizens, where we can apply rules as we want and then not when we don't want to, are not and also simultaneously still allowed to be treated however the government really wants. And what this really boils down to is the government choosing to go ahead and seek out the resources owned by the Nez Perce in an attempt to go ahead and bolster their own economy. They were stealing from these Native Americans and trying to go ahead and hide it under the ruse of a one entity that could simply sign it all away in every subsequent document after the 1855 agreement. The United States government offered to make an agreement with Chief Joseph pertaining to his land. At that moment, they established the privity that Chief Joseph was the title holder. Seeing as I don't see Chief Joseph's ratification on that document, I just don't see how it's valid. He's the title holder, yet he's not on the piece of paper.
We will now go and make our decision.
All rise. All rise.
The petitioner contends that the Court of Claims erred in its holdings that the 1863 treaty was valid and the Nez Perce tribe signed the 1863 treaty as one entity when it came to the specific territory known as the Wallowa Valley. Petitioner further contends that the Court of Claims erred with regard to Chief Joseph not having a recognized title to the valley. Petitioner also contends that the Court of Claims erred when it ignored the contract principle of privity that creates a legal obligation. We conclude that the legal analysis and factual findings of the Court and Claims were in error on all three counts and do not support its conclusion that the 1863 treaty was valid with respect to the conveyance of the title to the Wallowa Valley. We find that the Fifth Amendment Takings Clause does not apply in this case based on the evidence that the executive order signed by President Grant returning the valley to Chief Joseph. As we note in our decision in the Sioux Nation case, President Grant supported the Fifth Amendment takings of the Black Hill in the exact same time he was rejecting it for Chief Joseph in the Wallowa Valley. This evidence of the opposite position taken, President Grant proves that the Fifth Amendment takings was not the desire of the government when it came to the Wallowa Valley, and further, that the government recognized Chief Joseph's band as having title. Therefore, the judgment of the court claims it's overturned and is hereby ordered that the Wallowa Valley be returned to Chief Joseph's band of the Nez Perce. So it is ordered.
Wasn't that fantastic? I thought the students did an amazing job. It was a tough decision at the end, you could tell. Both sides put up some really good arguments. What was more surprising to me was the decision. I had no real idea how the court was going to decide, and for the students to all decide in favor of Chief Joseph is just amazing. So thank you for taking the time to watch this, and if you want more information, you can go to a website I've set up for my students for this assignment called chiefjosephappeal.com, and I just want you to know there are some of us out there still pulling for you to get your valley back. Thank you.